Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3159 et al., United States of America Appellant versus Ahmed Salim Faraj Abukhatallah, also known as Ahmed Abukhatallah, also known as Ahmed Abukhatallah, also known as Ahmed Abukhatallah, also known as Sheep. Mr. Leonards for the appellant, Ms. Wright for the appellee.
Mr. Leonard, good morning.
Thank you, Your Honor. Good morning, and may it please the court, Dan Leonards for the United States. If I might please reserve 2 minutes for rebuttal. When this court reversed the district court's initial 22-year sentence as unreasonably low, it declared that that sentence was far lower than could be justified on this record. And it repeatedly emphasized that not only had the district court failed to justify its massive downward variance from the bottom of the guidelines that would apply, even accounting for acquitted conduct, but that it could not do so on this record. The district court, nonetheless, on resentencing, increased its initial substantively unreasonable sentence by a mere 6 years, continuing to vary downward by more than a decade from the bottom of the guidelines that would apply, even accounting for acquitted conduct. That 28-year sentence remains shockingly low, given the gravity of Khattallah's terroristic offenses and the need to deter similar attacks from occurring in the future. And
help me out here, because when a district court judge sentences, they have the opportunity to use the guidelines, which are advisory, and then you have to give sufficient rationale if you're going to vary. And then, of course, there's statutory reasons to depart. They have already had a remand and then went up 6 years, providing some additional rationale. What I would not like us to do is be perceived as dictating a sentence. And so tell us more about particular legal reasons that would be sent back as a rule or something that the district court substantially erred, et cetera, because otherwise it looks like we're saying we're not going to be happy unless you get to 40 years.
I think that the court can look at the reasons, the justifications the district court gave on remand and find fault with them without declaring some broad rule that would apply in every case. For example, take the terrorism enhancement. The district court didn't find at the first sentencing that the terrorism enhancement somehow overstated Khattallah's conduct. But yet at the second sentencing, it declared that this act of terrorism lacked many of the hallmarks of the crimes that Congress was looking at when it created that enhancement. Well, that reasoning is both factually and legally erroneous. Factually, there is no more quintessential crime of terrorism than a completed terrorist attack on a U.S. diplomatic facility abroad during which Americans are murdered, including the first sitting U.S. ambassador to be killed in the line of duty in more than 40 years.
Okay, I understand that this was bad. I'm not denying that. But again, for example, do you feel like acquitted conduct was already taken into account with respect to the reduction in the guidelines from life to 40? That's what I'm trying to get at. Like, do you believe like there was some over accounting for some of that, and then that's why that sentence became lower?
It does appear that the district court was fixated on the acquittals to an erroneous degree. It emphasized at the end of its resentencing, it said, most importantly, the government has failed to prove the most significant charges here. But that ignores the significance of the crimes for which Khattalllah was convicted. If you took out the acquittals and the government never charged them, and you thought of this as a case in which Khattalllah is only charged with the 4 crimes he was convicted of, providing material support to terrorists, conspiracy to do so, destroying a U.S. diplomatic facility while putting Americans' lives in danger, and carrying a semi-automatic weapon while doing so. On the facts of this case, anyone would think that warrants a life sentence. And on the facts of this case, the guidelines would be 40 years to life.
Not anyone, because Judge Cooper doesn't.
Judge Cooper doesn't, but again, that's because he's focused on the government's failure to, the jury's acquittals of the murders, as though that suggests some meaning for the convictions. Like I think he thinks the convictions are less serious because the jury acquitted of the murders, but that's not so. I mean, I think Gailani highlights that. That's a case in which the defendant was acquitted of 280 some counts, including.
So I think, counsel, that we can find some legal errors in the court's reasoning. Things like, as you've mentioned, for him to just, I guess, disregard or not give proper account to the reversal after the first sentencing, where this court said you can't characterize this as a property crime, given that there were these two terrorism convictions. And yet he seems to do the same thing again. So I don't think it's difficult to find error or fault with some of the analysis that the district court did. But I think what Judge Childs might be getting at, and which I've been puzzling about too, is there's definitely potentially legal error for which we could remand. But then what is it that determines what's actually substantively reasonable? Because that seems to be something that's difficult to pin down using legal doctrine or whatever. And it just seems that the government has the sense that 28 is too low. And I think what Judge Childs might have been trying to get at, and also troubles me, is there some number that we think it has to be in order to be substantively reasonable? And how do we arrive at that number? Because what I see in this remand is we sent it back and the district court judge doesn't have the same view of what's substantively reasonable as the government. And there is a sense in this transcript that I've read pretty carefully of him just trying to vary downward to get to where he thinks there is a substantively reasonable sentence. And sure, we can say there was error in his analysis and his reasoning, but at the end of the day, he's going to come up with a number. And it's just hard for me to get my mind around, like, what is it that would be substantively reasonable? What do you think would be substantively reasonable? And how do we decide what's substantively reasonable for
Before
these
you
offenses?
answer that, what would be substantively reasonable is following the guidelines. My two colleagues sentenced people much longer than I did, but I sentenced under both. And every time I varied from the guidelines, not every time, but I was told they're there, they're reasonable, they're there for a reason. And they were mandatory then, so I had to follow them unless I could depart. I think every time a sentencing judge varies from the guidelines, he's running a risk. And I think our colleagues have looked at this already and said what he did was substantively unreasonable in no uncertain terms. Sent it back and he added 6 years when he was facing whatever 30 to life plus 10 for the 924C. I don't see, if we remand it to this judge, that this is going to resolve anything. And I understand the drawbacks of requesting something like this, but I'm wondering why you haven't asked to have it remanded to a different judge.
There's a lot going on there. If I might just start with, the government asked for life plus 50 in the initial sentencing. It asked for 60 years in the second sentencing. Judge Reinhardt, in his concurrence in Rassam, said he saw no reason why, in the case of a foreign terrorist, any sort of departure from the guidelines would be warranted. So I think that's where we would start in terms of thinking, in terms of substantive reasonableness. And I have more to say to your question, Judge Pan. To your question, Judge Henderson, we certainly considered asking for a remand to a different judge. That was not something that we have done in this case. Judge Cooper, throughout the course of this prosecution, showed an incredible depth of incredible thoughtfulness and care to this case. It's something he's handled for more than a decade. And I think out of respect for his role in this lengthy prosecution, the government has not asked for reassignment to a different judge. He certainly, for example, rejected the defense argument on resentencing that he could simply impose the same sentence and just give different reasons. He understood that this court had ordered him to impose a higher sentence. I think he, as Your Honor said, certainly ran a risk of reversal again by varying from the guidelines. And I thought this court said in no uncertain terms that a guideline sentence was warranted, that there was no way to justify anything than a guideline sentence. To more concretely answer your question, Judge Pan, in sentencing, there's, of course, a lot of discretion afforded to the district judge, but is nonetheless an abuse of discretion standard, which suggests that that can be abused. Numerous courts of appeals have said it is not a rubber stamp review. There must be something that falls outside of what everyone else thinks is reasonable. And so notwithstanding Judge Cooper's unique view of this case, when all members of the panel seem to agree that 28 years is too low for this particular defendant, then it is a substantively unreasonable sentence. And courts of appeals, not often, but somewhat commonly, have reversed cases involving even higher sentences. For example, the Ali case, where the defendant received 30 years, the Fourth Circuit reversed that as substantively unreasonably low. And that was a case in which the defendant didn't accomplish his terroristic goals. He was stopped before that happened. The same was true in Rassam. His 22-year sentence was unreasonably low. He was stopped before he accomplished his goals. From the terrorist perspective, this attack was a success. They breached the U.S. Special Mission. They burned it to the ground. They killed 2 Americans in the process. And even accounting for the fact that Khatallah acquitted for those murders, he endangered American lives. This was an infamous attack that was heard around the world. And under those circumstances, the leader of that attack certainly needs to spend more than 28 years in jail to have received a substantively reasonable sentence.
So I thought in reading this record that, Judge Cooper clearly was very thoughtful and was trying very hard to arrive at a sentence that he thought was fair and appropriate. And there might be some disagreement with the way he weighed things. But one thing that struck me as problematic was his attempt to divine factual findings from the jury's verdict. And it just seems to me that juries can, reach a verdict for any number of reasons, including a compromise, or they could find that maybe this defendant was involved in causing the death, but it wasn't proved beyond a reasonable doubt, but maybe by preponderance it was. So I just thought that there was a lot of time spent trying to divine what the jury factual findings were beyond just dealing with acquitted conduct, because you can deal with the acquitted conduct, but by just choosing, I guess, the lower guideline range, which is 40 to life instead of, what he originally started out with, life plus 10. But this seemed to be sort of the underlying or overarching concern that he had. And I really didn't see the government objecting or trying to correct that methodology. And even when the court asked the prosecutor, what do you think the jury meant? I don't hear the product saying, respectfully, Your Honor, I don't think that we can read factual findings from a jury verdict, and we don't think that's the correct methodology. I just don't see any pushback or objection to that methodology. And I'm wondering why. Do you agree that that's the correct methodology?
Well, so 2 things, Your Honor. It certainly is possible, if not plausible, that the jury thought that Khatallah caused the deaths by a preponderance, but not beyond a reasonable doubt. And that's what Judge Cooper found.
Yes.
So there's a finding here. So we shouldn't blind ourselves to the fact, despite the fact that he's acquitted of causing deaths, that by a preponderance, the judge found he was responsible for those murders.
There's no question. There were a number of factual findings that I felt didn't make their way into the sentence, such as that he found that the relevant conduct caused or resulted in death, such as that he believed that the verdict was that the defendant did participate in planning the attack and was in contact with the actual perpetrators on the day of, before, during, and after, all that. And the only, I guess, the district court said, I think this is explained by the fact that they didn't know who actually set the fire that actually caused the deaths. But the sentence doesn't reflect those factual findings. There's no question. But I guess what I found interesting about this transcript was just the methodology of trying to figure out factual findings from a verdict and the government not even objecting to that.
So I think earlier in the proceedings, there was government pushback on a lot of this fine parsing. So for example, the defense argued before the first sentencing that the way to read the jury's verdict is that Abukhatallah joined this conspiracy at around 11:45, after the gates had been breached, after the fires had been set, and only when he first showed up on camera. And the government disputed that, and Judge Cooper agreed with the government that the evidence showed that he procured weapons ahead of time, that he coordinated with members of UBJ, his militia, ahead of time. And so the court rejected that parsing. Likewise, in the first appeal, the defense argued that the jury had rejected facts sufficient to find the terrorism enhancement and the leadership enhancement. And again, we pushed back on that, and this court agreed that the acquittals don't reflect a rejection of specific facts. We have not challenged the district court's ability to subtract out acquitted conduct, which the guidelines now require, and that acquitted conduct was causing deaths. The jury's verdict reflects throughout that Abukhatallah was acquitted of the conduct at the annex, where another 2 Americans were murdered, and acquitted of the causing deaths. And so I think the way to see that is he participated in an attack intending to kill Americans, putting Americans' lives in danger, which this court found to be the best reading of the jury verdict. But that the failure of proof that led to the jury's verdict was they couldn't prove who set the fires. And because there were leaders of other militias and members of other militias, although I would think that the obvious conclusion is that they conspired and coordinated together. And it was certainly a coordinated attack. They all attacked at the same time. But the jury found some, sufficient lack of agreement and who set the fires to acquit of deaths. But again, the deaths occurred. The judge found by a preponderance that Abukhatallah was responsible for them. And his 28-year sentence, even subtracting out the acquitted conduct and focusing only on the counts of conviction, is shockingly low on this record, which this court has already found.
Should Al-Aman's sentence of 19 years in any way inform this appeal?
If it does, I think it only underscores how low Abukhatallah's sentence is. Al-Aman was convicted of, he didn't carry he didn't carry an AK-47, so he was convicted of the 2 material support charges and the 1363 charges. The jury couldn't reach a verdict on the causing death charges. He wasn't a leader. By all accounts, he was a small, timid man who was afraid of the dark and was effectively Abukhatallah's gopher. He's seen in the video in this case next to Abukhatallah leaving the talk with a map. And so given his lack of a leadership role, the fact that he had no semi-automatic weapon, and as I said, what was, I think, viewed as kind of a scared participant, I think the fact that he received 19 years only underscores how low Abukhatallah's sentence is by comparison.
And just a couple of the factual pieces. Age can be an appropriate basis for departure, but it also says that you need extraordinary circumstances. If somebody's going to be 80, once they leave Department of Correction or any prison, what do you perceive as the need for the extraordinary cases? What would that be?
Well, I can point to the facts of this case, which is with good time, Katala will get out in his 60s. He was in his early 40s when he was captured by U.S. forces. He was born May 7th, 1940 or 1971, according to Wikipedia. So, using that math with good time credit, serving 85% of a 28-year sentence, he would get out in his 60s, which, is ample time to, attack the United States again. And so I don't think this case presents the extraordinary circumstances warranting a massive downward variance based on his age.
And then in two of the actual explanations, it uses the fact that the 924C apparently was disproportionate, but uses that language twice to justify the sentence. Do you feel like that was an overcounting?
I certainly think the judge's analysis of the 924C charge was legally flawed. First, it's inconsistent with this court's, he said it is not necessary for deterrence, but this court already said the deterrence interests at stake here, which are preventing this type of terrorist attack and preventing people from leading them, support a stiffer, not a lower sentence. But also the district court characterized the deterrence interests as deterring the possession of AK-47s during a civil war in Libya. But that's not what we're talking about. No one in this case cares about people who possess AK-47s in Libya or in Benghazi generally. It is the fact that he carried this AK-47 during a terrorist attack on an American diplomatic facility and carried the weapon onto the facility. So he was prepared to use a semi-automatic weapon, like many of the terrorists did, to attack an American diplomatic facility. That's what we're seeking to deter. And by claiming that this is about deterrence of possessions of guns in Libya more generally is clearly a legal error that the district court committed.
And then the judge mentioned that the status as a deportable alien increased the severity of the sentence. What do we mean by severity?
I assume he meant length.
You don't see severity and length being two different things?
I do see them as being two different things, but my understanding is he was referencing a Smith departure, and it may be severity in the sense of it's not length, it is the fact that a deportable alien does not have the opportunity to spend the last 6 months in home confinement.
Okay.
So imprisonment is more severe than home confinement. And so I think that's the severity he was referring to. But as we pointed out, we don't think any sort of variance downward based on his status as a deportable alien is appropriate here, given that he would be returning to his home country where presumably he would be hailed as a hero, much like the Lockerbie bomber was when he was sent home from Scotland. And that was the concern that motivated the Ninth Circuit in part in Rassam, that he was going to be sent back to Algeria, his home country, where he not only could attack America again, but where he may be hailed as a hero.
Okay, and then one last thing. If we were to remand this, again, we're trying not to say that we're making a suggestion of what the district court should do. So how do you very clearly and cleanly get around that notion that this is what this court would be doing? Because the district court could just justify reasons and come to the same number.
I mean, I would hope that the court would not. Judge Cooper is a conscientious judge who attempts to follow what this court orders him to do.
But he did what he did. He believes the 28 years.
And he was hoping the government wouldn't appeal again, and we did. The closest I've seen, I think,
we're hoping you won't appeal again too.
I think one of the closest I've seen is, I believe it's Mamouni and the Ninth Circuit, where they gave a sort of summary at the end with instructions to the district court. And one was not the sentence to receive, but I believe they said the district court needs to give more emphasis or place more weight on. And so I think this court could signal more strongly than it did the first time, although I thought the first time was quite a strong signal of the court really needs to focus on the severity of these crimes, the need for deterrence, and the other factors that weigh in favor of a higher sentence.
And you wouldn't appeal, I presume, a sentence at the bottom of the guideline range of 40?
I can't say what the government would or would not do, Your Honor.
I know I'm not asking you to make a promise, but it just seems to me that
it seems unlikely that
reasonableness to you.
It seems unlikely that the government would take yet a third appeal.
Mm-hmm.
but the government has never asked for a sentence as low as 40 years. It
Mhm.
reduced its life plus 50 to 60-year request. Even a guideline sentence is not presumptively reasonable. And so there may be stakeholders who would want to appeal a 40-year sentence. I haven't seen a case overturning a guideline sentence as unreasonably low. I believe there are cases overturning them as unreasonably high, but it's not outside the realm of possibility.
Can I ask you about, do you consider packaging, which this judge insisted on, procedural? And if you do, I'm wondering why you didn't challenge the sentence procedurally.
I don't know the answer to that, Your Honor. I haven't thought about it. We viewed the packaging as a justification for the ultimate 28 years, and we think it doesn't actually justify a 28-year sentence. I hadn't thought about it as whether it was a procedural error, but I guess I should have.
All right. We'll give you some time to reply.
Thank you.
Ms. Wright?
Thank you. Lisa Wright for Mr. Catala. May it please the court. This court has only, as far as I know, in 21 years since Booker, found one sentence substantively unreasonable. That's what the panel found. We believe there was some flawed understandings that underlay that, but we accept, of course. But under Gardellini, the guidelines are not to be given the sort of weight that they would have to be given to find that Judge Cooper abused his discretion. I want to just step back that on the 4 counts that Mr. Catala was convicted of, he got either the maximum authorized by Congress or, except for one that got 2 less, or the guideline sentence. So count 1 maximum was 15 years. He got 15 years. Count 2 maximum, 15 years. He got 15 years. The count 16 maximum was 20. He got 18 years, only 2 less. And count 18, the guidelines call for a flat 10-year consecutive sentence, and he got a 10-year consecutive sentence. But nevertheless, the government argues that this total 28-year sentence is substantively unreasonable, which requires that no reasonable judge could justify this sentence, which is a 30% variance of 12 years off 40 years. The panel was concerned and found unreasonable what they thought was a 60% variance. And this is a 30% variance. The government acknowledges that.
It seems to me, Ms. Wright, that in terms of the guidelines and the statutory maximums, et cetera, really any sentence could be justified by running things consecutively, by saying that the 924C is 10 to life. So it just seems that the whole range of sentences was available. And so all of these considerations are just logistical things that you would have to put in place to get to the number that's the correct number. And it just taking a step back, looking at this case writ large, we're talking about a defendant who was a leader in planning an armed, highly violent attack on a U.S. diplomatic facility. Deaths resulted from it. This is somebody who procured firearms in advance of the fight, warned people away, don't interfere, don't get involved, send your men away, who was, one can infer, quite involved on the actual night that these events occurred, because there are phone records that show him talking within half an hour to people who are on the scene, perpetrating the events. And so the question is, that conduct, which he was found guilty of, putting aside the deaths, what is an appropriate and reasonable sentence for someone who does something like that? And I think we can sort of descend into the details and the minutia about, percentages and this, that, and the other. But I just think the overarching question when we're talking about substantively unreasonable is, this is what the guy did. Does 28 years seem to cover it? And he went to trial. It's not like he pled, there's no kind of mitigation in that respect. And 28 just doesn't seem to capture the seriousness of the conduct.
Well,
That's just kind of like the bottom line on substantive reasonableness to me.
I would say that that is really substituting Court of Appeals judgment for Judge Cooper's judgment as Gardellini says is not
Well,
supposed to
we're
happen.
required to review for substantive reasonableness, so it's not like I just decided I wanted to like
No, I understand.
opine on this. It's before me.
Right. No, I understand. But the amount of deference that needs to be given is so great. And I hear one point Your Honor just made about the wide range of sentences available and up to life and all that. That would require an upward departure, just to be clear. So
No, I understand that, but I just think a judge could justify any sentence up to life on this record.
That's
by employing the tools, as you said. Now I'm doing upward variance on the 924C. I can get to life. So it's just, it turns out like the bottom line is, what about this number? And when you think about factors that were identified by the prior panel, such as you can't call this a property crime, we are talking about deterrence of, potential terrorists who want to do harm to America. These sentences have to, reflect that we take this really seriously and you're going to get a stiff sentence. All of these considerations kind of go into that reasonableness calculation. But at the end of the day, it's kind of, this is what he did. And does this number reflect it? And I just feel like that was kind of lost in this sentencing.
I don't think that the district court decided this case accepting 100% of the government's narrative. They just didn't, and the government doesn't accept that. And
But there are factual findings. He said by a preponderance of the evidence that this conduct resulted in death. He said he made a finding. He said the best. So I kind of don't think it's correct to try to figure out what the jury findings are, but to the extent he did, he said the jury's finding reflected that Mr. Abukhatallah did participate in the planning and was a leader, et cetera. It was definitely terrorism, et cetera. But the most common sense, he said, view of the verdict is that they just didn't know who set the fire that caused the deaths.
But the government the judge does not have to sentence on his preponderance view. He's allowed to, but he doesn't have to. Under Kimbrough, he's allowed as a policy matter to say, I'm going to honor the jury system as the crown jewel of democracy, and I am going to balance that and sentence
No,
based.
I agree. But then we're at a guideline range of 40 to life. So then we start from there. Like if you want to take out the acquitted conduct, we're at 40 to life. And now acquitted
that
conduct has been taken care of.
Yeah,
Where
well,
do we go
not
from there?
entirely, because it's not the case that the acquitted conduct only bears, the guidelines are 3553 factor, A4. The fact that he didn't cause deaths, the fact that the district court had a sense of what the jury thought had actually occurred, those factors can factor into A1, A2, A3 as well.
No, I agree with that, Ms. Wright, but he said what he believed the facts were. And the facts were that Mr. Abukhatallah was a leader. It was terrorism. He did participate in the planning. He did all of that. And the verdict is explained by the fact that the jury didn't know, he thinks, this is what Judge Cooper found, didn't know who set the fire that caused the deaths. So he should be sentencing on that conduct, that he did participate in all of it, that he was a leader, that it was terrorism, all of that. But this, I just don't see that analysis happening.
I don't see that he has to sentence based on his findings as opposed to what he thinks the jury found.
Doesn't he have to sentence based on what
By
he
a
finds the facts are?
preponderance? By a
Then what is he
preponderance.
sentencing on if he's not finding based on the facts that he found?
He said, I am honoring the jury's verdicts. And I think he says many times, based on what I believe the jury found.
But he doesn't say that in the context of all these other variances.
I think he does, because he says in light of the jury's verdict is partly why he's saying the terrorism overstates, because there was no deaths. And I mean, I think he does use that phrase over and over. And
But is that legal error though? Like in that particular instance, for him to say that this terrorism overstates and this is not what Congress intended. And then you read what the definition of terrorism, and it includes damaging computers.
yeah,
I mean, was there any basis for him to say that this wasn't terrorism in some form?
I mean, that's a point I wanted to make, that there could be some procedural things he said that aren't right or whatever. The court could find that, but the government has not made a procedural claim. They can't get relief because the judge said something. The question before this court,
But is it substantively unreasonable to say something that is legally incorrect and then base your sentence on it?
no, because
not?
because the substantively unreasonable is about, given the facts and circumstances, could a reasonable judge get to this number? Not necessarily even.
But is a reasonable
Specifically-
judge presumed to be one that is not making legal errors or no?
I mean, legal errors like that are procedural. The government was welcome to appeal that sort of thing, but they didn't. And then it would have to go back for him to like eliminate whatever the error was and do it again. And they'd opted not to do that. They're going,
But are you saying that when we review for substantive unreasonableness and we see legal error, we have to ignore it?
well, when they don't appeal, not that you.
No, but I mean, as it relates to reasonableness.
I mean, I wouldn't say it's legal errors. I don't think really factor in. I mean, I think you look at the facts and circumstances. That's what Gardellini says. And the question is just, can you get there? And I understand.
But if you can't get there without legal error, you still think that can be reasonable?
If you can't get there, I guess if you're saying like, that's not a proper fact and circumstance, maybe that might be. But I mean, I don't think anything he said here, the government admitted that a lot of it is permissible. I did want to point out that.
Well, what did the co-conspirators get? Because that's also a
Right.
comparator issue and whether or
Yes.
not it's reasonable.
Well, I think this, Mr. Leonard's just said, I think that, I think his name is Ilman, got 19 years and he was convicted of basically the same things except the gun. Well, if you think about it, the gun is 10 years. So that's really that's comparable. And the government dismissed their appeal of Mr. Ilman's sentence. They let that stand. But for Mr. Abukhatallah, they're taking a different approach. And I think the government
But
is
the consecutiveness of the 924C was mandatory.
correct.
But then why doesn't your client have more to offer than just the gun? In other words, you're trying to make it sound like, oh, that's comparable because you had to have 924C and get the extra 10 years. Take the gun out. Your client still has more that happened that he's
guess-
responsible for.
I'm saying that Mr. Abukhatallah got essentially 18 years on the counts that weren't the gun, and
Mhm.
Mr. Ilman got 19 years, and the government dropped that appeal.
But he shouldn't get less than
Yeah, that's.
I
what I'm
mean,
getting at.
his.
I don't think we're in the
As
business
Mr. Leonard
of
said.
nitpicking over like a year or whatever, or even,
No,
but
you
it's-
have a leadership role
Yeah,
in
leadership
terrorism.
role.
but I mean, this court never approaches these cases like that where it says, well, I think a leadership means this isn't high enough. I mean, it's never happened in all these years.
But isn't it, even if we don't have to get that granular, isn't the fact that for the same offenses, Mr. Abukhatallah was a leader and he did a bunch of things in the record that, showed his awareness of what was happening and his intent that it happened, et cetera, compared to somebody who got a greater sentence just for those 3 counts, who was his subordinate, and I guess what Mr. Leonard says was his gopher. That doesn't seem reasonable.
It doesn't seem reasonable.
Does that seem reasonable to you?
Yes, it does.
Really?
Yes, I'm not saying that if I was the judge, I would set it up that way, but this
Wait, but
court-
why is it reasonable for the leader and the boss to get a lower sentence than his gopher for the same charges? Let's
Because
put
the-
aside the 924C.
the question is just, is 28 years a reasonable sentence for what
No,
Mr.
no,
Abukhatallah
no.
did?
But
That
the
is,
part of reasonableness is it reasonable in comparison to what other people are getting for similar conduct or different conduct? That's got to be.
I mean, this happens all the time where people do not end up, things are not directly, who knows what else Judge
Unless there's a
Cooper thought
5K
about Mr.
involved.
Ilman. We don't know what his other factors were, et cetera. I just think the court needs to.
You usually get a 5K substantial departure, perhaps if you were a higher leader, but there's something that you've offered up to get to that place.
Yeah, I don't think we know enough about Mr. Ilman's sentence to say that somehow that makes this substantively unreasonable. I think at the time, I don't think the government made that argument at the time of the sentencing, I think I have the timing right, I know he had been sentenced, let's say that, by the time this happened. I didn't hear the government saying you have to give him at least more than,
I don't
he
think
did
you have
get.
to. It's just when we're trying to get at substantive reasonableness, we're struggling a little bit too and trying to figure out what are the contours of that. And so we're looking for like the circumstantial evidence
Right.
that indicates whether this is reasonable or not.
Well-
And certainly what your co-defendants get has to be part of that.
I mean,
analysis,
if
right?
we were doing that in other cases, there would be so many substantively unreasonable sentences. This court's never found one. That's not
Well,
how.
sentencing is of course individual based on the defendants. But if you were to tell me, well, the gopher cooperated and got, substantial assistance time, or it was something like that. And was there anything like that? Or are we just talking about the same conduct?
That was not discussed by, that was not put into the record one way or the other. I don't think if in his sentencing or argued like that.
Okay.
I mean, I just think the degree of discretion is not being appreciated. And also I think that the government.
We're trying to figure out what are the limits to the discretion in your view? Because if we are here, it's before us. We're reviewing it.
Extremely limited. They could not be more clear in the law that at post Booker, there's just an incredibly wide range of reasonable sentences. And to say that a 28-year sentence is insufficient when it's the maximum minus 2 years plus the guideline range. And
I'm sorry, what is
It's
it?
not the maximum.
it's the maximum on each count.
Okay.
Minus 2
Concurrent.
years, concurrent. But like to argue that there's a requirement substantively that no judge can give concurrent
Well, the
time.
guidelines say that if the guidelines are higher than accumulating the maxes, like you should run them consecutive,
We
right?
totally disagree that that's what it says. It does not say if the guidelines are higher. It says if the total punishment is higher. That's the point. It's not saying what does the guideline sentencing table say. It's saying what sentence have you selected? Once you select your sentence, we're going to figure out how to allocate it. And the
But if
guidelines
you
were
want to select a
restricted.
guideline sentence, then you have to run these consecutive.
If you what?
If you want to select a guideline sentence, you have to run these consecutive.
That's why he didn't select a guideline sentence. That was one of his justifications, because he doesn't believe consecutive sentencing is appropriate when it's essentially the same conduct. And there's lots of authority for
We're
doing
back to
that.
the ultimate reasonableness of the conduct and the number. And
Well, I'm just pointing to the
Yeah.
different rationales he gave, facts and circumstances, which by the way, were not discussed by, but not, sort of in front of or discussed by the panel because, he said what he said the first time, highlights the first time. The second time he says, let me go through this more. And he puts in new facts and circumstances. He adds 6 years. He talks about, he does Dean. The government admitted below that Dean was a proper thing the judge could consider, but he didn't do it the first time. And our point is now he has. That can account for as much as 10 years. That's a perfectly legitimate departure ground or variance ground.
the one thing I thought was missing, Ms. Wright, was just, he never said why he thought 40 to life was not a reasonable ground. He just immediately started, I guess, trying to find reasons to vary downward to get to some lower number without really addressing. I found it, maybe it's because it was a second sentencing and there were two, but there wasn't just the whole, this is what the defendant did. This was very serious. There's different deterrence. The
All that-
guideline is this, but I don't think the guideline is reflective. I don't know. It just, he immediately went to varying downward without really explaining why the guideline range was not
Yeah, I think
appropriate. And that just confused me.
well, I do think a lot of things had already been said, either,
Yeah, I read that
Yeah,
one too.
but, I mean, and in his opinions and whatnot, he made clear, like, he did say that, but, he, I would say as to why 40 is not, he said basically, and I guess this is the gist of things, he said an actuarial life sentence is too much. And I just cannot imagine that a district court isn't the one who gets to decide that when he sat through the whole trial and knows the case best, read all the jury notes, understands everything about it. The government just,
I actually was wondering about that because there was some discussion with Mr. Leonard's too about this, that he said that if this defendant got to be an old man, it's unlikely he would harm America again or would have the opportunity to do so. And I was just wondering if there's any support for that, because I guess there are cases that say that terrorists are the least likely to be rehabilitated. I think if you are somebody who goes out and I guess mugs people on the street, you're less likely to do that when you're 80. But if you're somebody who doesn't go to the scene of the riot, but does all the prep work and the masterminding, I don't know why you're limited from doing that when you get older. I mean,
Well,
look at all the old people who are leaders in our government. I mean, I don't, if you're like, if you're the guy that, is the mastermind and just calls the shots, I don't know why being old would prevent you from continuing to do that.
Well, I don't think he relied on that as some reason to go down. Okay,
I thought it was
he just
part of it.
mentioned it when he was talking about whether a Dean variance was appropriate in this case.
But he also said for specific deterrence, he doesn't think this defendant is likely to do that. And I just don't really see why not.
Yeah, well, we had just cited generic, like you're saying, we cited, like we always do, that things go down with age. And all he said is, I don't doubt that. And that would be true of you, but he didn't rely on that to go down. He was just saying that's not a reason that I shouldn't grant a Dean variance, which the government admits he can grant a Dean variance. And then on this, the government, I just want to say this one thing before I forget, that I just think the government isn't accepting that what the verdict even was. If you look in their summary of argument, it's only a few sentences, but they describe the crimes of conviction completely wrong. They say the crimes for which he was convicted are, quote, conspiring with and providing material support to the very terrorists who murdered 2 Americans and went on to murder 2 more. And if you look on pages 629 and 630 of the panel opinion, it's very clear that that is not what the panel says the verdict was. They're saying the best explanation is that the government did not prove that he really any conspiracy with any other militia, but certainly not the ones that set the fires. That's what it says. It
But who
says
is he conspiring with?
his own militia people.
His own militia people were the ones on the scene, like the 3 of them.
There were some, but there were so many militias. And I mean, the panel is saying, I should grab it.
Are you saying that he wasn't convicted of conspiring with people who perpetrated the attack?
No, not the attack. He says conspired with the very people, very terrorists who murdered the Americans.
Okay.
That's wrong.
Okay.
The panel says it's wrong. And they say Judge Cooper's right that that is not what they found. So I just think that's in their summary of argument. And it just indicates that they just aren't grappling with what actually that. And that's just one aspect of the judge.
So putting that aside, I feel like Judge Cooper should have sentenced based on the facts that he found. And the facts that he found were, putting aside the resulting death, because he's entitled to discount the acquitted conduct, which he did by, if we just go to the different guideline range, I think
at least on the guidelines,
at least on the guidelines, he discounted. But he found that the defendant did conspire with people who were on the scene and was closely in contact with them during this whole attack.
But he decided as a matter of policy that he thought honoring the jury verdict merited putting aside, he says this so clearly, putting aside his own personal opinions.
Once the guideline has taken care of that, what more can he do with that?
Because
that's
there's
reasonable and appropriate and not double counting.
Well, there's all the other 3553 factors. That's one thing. But also just some of these things he relied on are just so well established, like Dean, the feeling that consecutive sentences are not appropriate here. It's not correct that 5G 1.2 is telling him he has to try to drive towards the sentencing table, which, by the way, I mean, if there's any doubt in the court's mind, I want to discuss the fact that the sentencing table for this is not 30 to life. It's 30 to 50. There is no life sentence available.
You forfeited that though, haven't you?
How can I forfeit something? I'm not making a claim based on it. I'm simply telling the court, if they want to know what the correct comparison is, this is the correct comparison. I'm not claiming anything.
But if the district court, if you didn't make this argument in the district court and the district court didn't abide by it, are we allowed to revise the guideline range?
This was perfectly clear in the district court. The government told the district court, we want a life sentence. You're going to have to depart to get there.
No, I understand.
And we said the same thing at sentencing. And it is true that as the case went on, the language was not precise in saying life. People are focused on the low end. Nobody is thinking the panel is going to take.
I think this comes back to my original point, which is that really the full menu of sentences was open and then you could adjust.
Including this sentence. I mean, that's what our point is. There's a huge menu of sentences and he chose this one. And
I know, but if he had departed down to probation, you would agree that was unreasonable.
at some point, yes, but like at what point?
So that is the question.
But at what point are
is it
they
unreasonable?
satisfied? I don't think we're supposed to be like dancing on the head of a pin here. It's not like he said, I considered all the other sentences. I considered 25. I considered 30. This is where I landed. It's hard. He's having to balance different policy considerations and concerns and plus facts about Mr. Abukhatallah. You know, also, I just wanted to, the government actually said, and I don't want to forget to say this, on the issue of whether he can sentence based only on what the jury actually rejected or what they necessarily rejected or what they actually rejected. And in response to our rehearing petition, they said, quote, nothing about the panel's discussion addressing the proper guideline calculation absent acquitted conduct prevents a district court from accounting for facts that it believes the jury actually rejected. They admitted that on rehearing, that he's allowed to based on everything he's witnessed, his 7 weeks of trial, the jury notes, et cetera, watching the jury's faces as they listen to the government's witnesses, he's allowed to rely on that. Also, they don't seem to accept that there were facts that the judge didn't accept as part of, they didn't accept all of their narrative by preponderance. He said that Mr. Abukhatallah was perhaps not the stone cold premeditated terrorist the government made him out to be. I mean,
What was the
call that
next sentence?
faint praise,
What
but
was the next sentence?
he was perhaps not the stone cold premeditated terrorist the government makes you out to be.
And
I don't have that in front of me.
then he said, but you're the person who could resort to violence to get what you want.
He said but that's not, he's saying, he's making a distinction between those. Saying someone is a product of a culture of violence doesn't mean they're
Or that he would resort to violence.
to get
That
to.
he's a violent person is basically what he
Well,
was saying.
so are lots of people. I mean, I don't understand I'm saying that the court rejected in part the government's narrative as a matter of factual finding. And unless they're saying that's clear error, we can't just decide this case as if their version of what happened is correct when they've already admitted that.
I'm just looking at the factual findings that Judge Cooper found, like when he was deciding what the guideline range was. And it doesn't seem that what he said at the sentencing is consistent with that.
That's right.
You can't say that this is a property crime while you've made a factual finding that there was a leadership role, there was
He said
terrorism,
the jury
there was planning,
found.
people died. No, his findings.
No, but he said the jury found essentially a dangerous and violent property crime. He didn't leave out the dangerous and violent part. So he understood that there was,
But they found terrorism. He left the terrorism part out.
they didn't necessarily reject terrorism as all that's been found. Oh, you're saying the counts.
Yeah.
Yes, and he got 10 years for that. He got 10 years for the terrorism because without the terrorism enhancement, he would have been at 6.5 to 8 years. It raised it to 30 to 50. So, and he gave him
It
28.
was terrorism.
I mean, unless
You're
the
not
rule
debating
is that
that, are you?
terrorism means you die in prison in every single case, which, if that's the rule, then I guess we should be honest about that. But it's not, you can't get there and defer the way you're supposed to defer under Gardellini. I mean,
We need to move on.
Okay.
I'm
just
sorry.
One thing, are you still holding on to your procedural defect argument?
I am satisfied with what I've said in my briefs about it unless there's questions.
Okay, thanks.
All right, let's give Mr. Leonard 2 minutes.
Thank you, Your Honor. I'll stick to it. Very quickly, in terms of the defense argument about Judge Cooper saying legally erroneous things and whether that's a procedural or a substantive defect, it is a substantive defect, as this court and Gall both made clear. As this court explained in its first opinion in this case, when reviewing for substantive reasonableness, this court must ensure that the district court has explained its conclusion that an unusually lenient or an unusually harsh sentence is appropriate in a particular case with sufficient justifications, while a legally erroneous statement is not a sufficient justification. The district court found that Abukhatallah was someone who might readily resort to or order violence in furtherance of whatever ideological or political goals he might have. In other words, a terrorist, and a terrorist who committed a completed act of terrorism in this case. And his leadership role distinguishes him from Al-Imam. One of the reasons the government did not use Al-Imam as a comparator is we had appealed his sentence. We thought it was too low. And that case was still on appeal during the resentencing and when we filed our opening brief in this case. Ultimately, the parties resolved that on appeal. Al-Imam dropped his appeal, the government dropped its, but that doesn't mean the government accepted Al-Imam's sentence, but his sentence underscores how unreasonable Khattallah's was. The leadership role that Khattalla had doesn't just factor into the guidelines, but it captures the entire attack. He's a cause of the attack. Al-Imam was not among the men procuring weapons ahead of time. Al-Imam was not on the one being called by the leader of the February 17th militia, who Khattalla said, do not interfere. Al-Imam was not, in this case, bragging afterwards that he wished he had killed more Americans, including those at the airport. And so for all of those reasons, we think that Khattalla's sentence is substantively unreasonably low and should be reversed.
All right, thank you. Thank you.
Case number 25-1152, John Doe petitioner versus Securities and Exchange Commission. Mr. Havian for the petitioner, Mr. Yoder for the respondent.
Morning, Your Honor. May it please the court. My name is Eric Havian. Excuse me for a second, Your Honor. And I represent the petitioner, John Doe, in this appeal. It's important to keep in mind, I think, that there's no dispute that but for John Doe's extensive documentation and 9 days of being interviewed by government agents, the worldwide bribery conspiracy would never have been uncovered, and the government would not have recovered hundreds of millions of dollars. There's no dispute about that. And there's also no dispute that under the until very recently, John Doe would have received an award from the commission. But 1 year ago today, the commission abruptly changed the rules of its whistleblower program. And it changed them in a way that essentially flipped the existing rule upside down and essentially put it in a position of being an outlier among all of the other whistleblower reward programs. And in that situation, we believe that the commission's justification for this abrupt change, where it departed from the CFTC, from the NHTSA whistleblower program, from the False Claims Act,
Well,
can't be
agency is
supported.
allowed to change its policy, isn't it?
Of course. They can do so through notice and comment rulemaking, but they can't do it in a way that is inconsistent with the statutory text. And that is our view here.
Yes.
That's our argument here. So I have
I have a lot of sympathy for your client, but why didn't he go to the SEC when the DOJ told him, or told the journalist to tell him he should go to the SEC? And then 6 months go by and he would have been fine if he had just they advised.
we don't know what the journalist told our client. But the point is, Your Honor, this is a statutory interpretation case. So I don't have an answer for the court's question. But he's a foreign.
Other than the statutory interpretation too, there is a provision where the agency can waive all these requirements under the correct circumstances. It seemed like you have a strong argument that, the policy changed right before, he was due for an award, et cetera, but you didn't appeal that aspect of it.
We did not, Your Honor. We felt that the statutory interpretation question was really critically important, and also that the commission has a lot of discretion as to
We
when.
just reversed on.
We submitted a 28-J letter, and
I
that's.
understand. I was on that panel.
I know you were. That's one of the three legs of our argument here is that decision. And I plan to talk about that. We can talk about it now if you want. I was going to put it a little bit later.
No, go ahead and talk about your statutory interpretation.
Okay. So the first leg of our argument is that if you look at the key phrase here is original information. That's the critical central facet of the whistleblower program.
But is it really 3 steps? You are the whistleblower.
Yes.
You, as whistleblower, provide the information. And 3, the information leads to the prosecution of the case.
Yes, Your Honor.
Okay.
And original information is defined as any information not previously known to the commission.
Okay, so let's say we give you that, but you still have the whistleblower having to provide the information too. And I can only suspect that maybe the policy behind that is, let's say your information gets in the hands of a journalist or, anybody else. You have to be the one to go to the SEC to kind of take ownership, almost like the lottery ticket, you must present yourself. And so maybe that's part of the whistleblower must be the provider of the information. And then you have the 120-day clawback, essentially giving you another opportunity to get there in time, but not 8 months later.
Your Honor, this is where the decision that came out on Friday, I think, is very important.
Okay.
Because on Friday, this court construed the phrase, what does it mean to voluntarily provide original information to the commission?
Mm-hmm.
And the commission here argues that phrase provided to the commission means you have to do that by handing it to the commission directly. The trouble is you cannot reconcile that interpretation with what this court addressed on Friday. And the reason you can't is the issue in that case was when you hand information to a federal agency like the Justice Department, are you voluntarily providing that information to the commission? And this court said yes. And the reason you don't have to provide it, you don't have to hand it over, is that because when you hand it to the Justice Department, they routinely share information and referrals with the commission. And so this
Maybe overreading that case a little bit.
well, the
That
commission
was about voluntarily, whether you came in first or they had to subpoena you and bring you in.
I understand that,
I think you're overreading a little.
but the regulation doesn't create that distinction. The regulation says if you provide it to the Justice Department, then we will deem that you voluntarily provided it to us. So how can those things both be true? How can the phrase, Congress used the phrase delivered to, or provided to the commission? Their entire argument is that phrase can only mean one thing. You handed it to the commission. How can they have a regulation that says?
Well, there's a
you
whole
will-
statutory scheme here, right? You can hand it to the commission directly. If you hand it to an agency like the Justice Department, then there's this look back provision where we can deem you to have given it to the SEC if you file with the SEC within 120 days. So there's actually a whole
Right.
procedure for this.
But the look back provision, the commission has always interpreted and interprets it
Well, you
here.
wouldn't need the look back provision if giving it to the Justice Department equals giving it to the SEC.
The look back, if you look at the language of the look back provision, it doesn't say you're ineligible if you don't meet the 120-day requirement. It says we will not, if it is designed to address multiple whistleblowers. It preserves, according to the SEC in their brief here, footnote 4 of their brief, it's designed to address the situation that preserves your place in the queue. So if there are multiple whistleblowers, if you look at the language of the regulation, it says you will relate back to when you first went to the Justice Department, as long as you give us your TCR within 120 days. It doesn't say you're out of luck. So if there are no multiple whistleblowers, then the provision doesn't matter. So we didn't comply with the 120-day provision. What is the conclusion? Our information does not relate back, but it doesn't have to because there's no second whistleblower. What the regulation, the commission itself in this regulation, offered a regulation that is inconsistent with its current interpretation because it came up with this on the fly in an enforcement proceeding. And so how can you even do a relation back in the sense the court is saying when Congress has said you have to show, this is their argument that they're making. You provided information to the commission, and they say that can only mean one thing, directly provided to the commission. Well, if Congress,
That is the most natural reading.
but if
The
Congress,
language is whistleblowers who voluntarily provided original information to the commission that led to the successful enforcement of a judicial or administrative action. The most natural reading is what you gave directly to the commission led to the successful enforcement.
Your Honor, I don't believe you can reconcile that interpretation with the commission's own regulation that says if you give it to the Justice Department and they later give it to us, you have now voluntarily provided original information to the commission. I don't see how those two can possibly be compatible, because you're saying Congress required that
So what are you relying on for that?
there,
Providing it to the Justice Department equals providing it to us.
the court's decision addressed the commission's regulation 21F-4A2. And so if you look at 21F-4A2, it says,
Is that somewhere in
I'm sorry, I'm looking at
your
this.
addendum or something?
I'm sorry?
Is that in your addendum or something? I want to.
Yeah, it's on the 28J letter. Yes.
Okay.
I didn't
have it
include
too.
I didn't include the regulation itself, but it is we've referred to this regulation throughout.
Okay.
And 21AF2 says your submission of information to the commission will be considered voluntary if you voluntarily provided the same information to one of the other authorities defined above. So my question is, how can that be possible? How can that regulation exist
If you voluntarily provide to the other ones and then you file with us.
That's not
in
what it-
120 days, is that?
That's not what A2 says. There's nothing about 120 days. That's a separate regulation that the commission interprets to mean if there are multiple whistleblowers, if you give it to the Justice Department and
Is that
then
a regulation though?
that's a different regulation.
But the statute says to the commission.
That's my point. The statute says to the commission. And the question is, what does it mean provided to the commission? What does the word provided mean in the statute? And what I'm saying is this regulation, as interpreted by this court in Friday's decision, but on the face of it, this regulation can't be squared with the commission's interpretation of the word provided. How can the word provided for purposes of voluntariness mean you can provide it to the Justice Department, and that's providing it to the commission? How can it mean that in that context, and yet in this other context?
Okay, now I'm looking at 21F4A2. It
Yes,
says your submission of information to the commission will be considered voluntary if you voluntarily provided the same information to one of the other authorities identified above. That, you're overreading this. This is not saying providing it to one of the other authorities equals providing to the commission.
no,
That's
but
not what this says.
but it has to mean that, because
No.
otherwise you won't.
We'll consider it voluntarily provided. That means we're not going to prevent you from getting an award under these circumstances. That's
Right.
not.
But if
it says.
if the commission is correct in its reading of Dodd-Frank, that Dodd-Frank requires you to hand it directly to the commission, or you don't
Let's stick
entitled
with the
to.
statute. The statute says to the commission.
Yes, it says to the commission. And this language suggests that that does not mean handing it personally. This language suggests, and the court's opinion
But
suggests.
aren't you essentially just asking a whistleblower to show up? Because again, you could get it in the hands of a journalist who turns it over, but you didn't intend to be a whistleblower. But then later on, 5 years later, you want that credit when you see that, oh, there's some award or something.
Well, when you hand it to another federal agency, there's not going to be any 5-year time period. And that's what our client did here.
But my intent of the question is that the whistleblower shows up. If you give something to a third party, whether it's a journalist or even not the DOJ, they're asking you as whistleblower to show up to say that that was my intent for you to have this information, because somebody could just, in these days, just hand it over.
Well, let me try a somewhat different tack.
Okay.
I think this argument is a very clear textual indication, but if you look at the definition of original information, Congress didn't come up with that out of the blue. The definition of original information is all information not known to the commission. That's the core, with one exception and one exception only, which is information that's from an original source. So that's the only exception Congress
If we
created.
give you that, isn't the whistleblower still required to show up?
Eventually, just like under the False Claims Act, you're required to show up. You're required to file a complaint at some point.
Okay, but then this one doesn't show up in that 120-day period?
Well, again, the 120-day look-back period is something that relates to the sequencing if there are multiple whistleblowers. It's clear because that's a separate regulation that
Okay,
says,
so go back
we're going to
to
give you relation back, so we don't get relation back.
Okay, so let's say that there is no other person. You have a person who, the alleged whistleblower hands it over to a third party hands it over to the SEC. You go way beyond 3 years. And then you want to have a look back, but there's still nobody else who gave the information over. Do you still get credit?
You don't get a look back, but you've satisfied the requirement to provide information to the commission as the regulation states, as this court noted in its Friday decision. But more
I think you
importantly,
have to satisfy all of it, because if they've already proceeded with their investigation based on other information and yours comes too late and it hasn't led to a successful enforcement, then you don't get an award.
well, Your Honor,
Right?
this issue, this language was based on the False Claims Act. There's no dispute about that. And we know what the purpose was when Congress used this same language, original source, in the False Claims Act. This court's Findley decision explained why Congress did that. And it was because of exactly what the commission is doing
I
here.
think it's a little different for this reason. It seems to me that I think that you have a plausible reading, but I think that the better reading is what the government is proposing, which is that this language is straightforward and means what it says. It says you have to provide it to the commission, and that information has to lead to the successful enforcement. And the reason is, in this context, we're trying to incentivize whistleblowers to bring their information to the SEC so that the SEC can investigate. The whole purpose of this program is to assist the SEC in its enforcement. So if you give it to a journalist, if you give it to the Justice Department, you're not assisting the SEC in its enforcement goals. And so that's why you have to meet these requirements.
Your Honor, right?
It's very unfortunate. I just feel like your client is the source of the information. If only he had gone to the SEC when he was told to do so, he would have gotten the reward that he deserved. But under the circumstances, he seems to be out of compliance with this statute. And I think that I've puzzled over this a lot. I think that your interpretation is plausible, but I think this is the better interpretation because of the purpose of this whole framework.
Well, let me see if I can address that concern, because I do think that ours is the better reason. And I think it's because three different things all point to our interpretation. The first is the language of this rule. And I think when the court, I think sitting down and looking at how can this voluntarily provided to the commission mean you can hand it to the Justice Department in one context, and yet it means no, you have to hand it.
It'll be considered voluntary.
I know, but you have to stay with.
See that this being that direct, and it's a regulation and we're interpreting a statute.
Well, I'm talking about the commission's interpretation of the Dodd-Frank language. I think the Dodd-Frank, the second piece of it is when you look at the False Claims Act, this same phrase was used to get to the opposite result.
But they're not trying to, in this context, we're trying to get people to give information to the SEC. So we're incentivizing people to bring things to the SEC.
And I think that
That's why
is,
it's different.
and that's, the same is true of the False Claims Act. The incentive was to bring information and evidence to the government. And in the context of in this instance, this exception, this original source exception has never, as far as we can tell, we've looked at 15 years worth of cases. We cannot find a single case where this rule would have been invoked. And yet this was the one exception that Congress created to the original information definition. One exception never invoked. It's the SEC's interpretation of original source makes it a dead letter. It's a central feature.
It's not a dead letter because there is a situation in which somebody else would take your information, bring it to the agency. Agency doesn't act on it. You come along later and bring your information. Then it acts on it. So it does lead to.
I understand.
And then this is the whole scenario that is in the reply briefs, but that shows that doesn't make it a dead letter. It's all about the order in which you showed up, which is another argument.
It makes it a unicorn because we can't find a single case in 15 years and they haven't cited one. And if you look at the False Claims Act provision, it is designed to have the opposite.
Doesn't make it a dead letter.
No, it makes it, Your Honor, you're correct. It makes it a unicorn. And the problem is, it's the opposite under the False Claims Act. Congress used this language in the False Claims Act to stop what the SEC is doing here, which is that if the government already has your information, even if it's your original information, we can launch an investigation and you get nothing. Congress said that, this court said in Findley, that killed the goose that laid the golden egg. So Congress passed the original source rule in 1986. Then the same Congress in 2010, which was amending that rule, passed this original source provision. But now the SEC says it means the opposite. It means if the government has your information,
So
you are out of
I'm
luck.
wrong, because I'm not an expert on the False Claims Act, but they are just trying to get people to come forward and whistleblow on the government. And so we want to incentivize whistleblowing on the government. And so that would, it seems, allow a broader definition. Whereas here, we only want to incentivize people to come to the SEC. And so that's why this provision reads as it does, to the commission.
Well, Your Honor,
Let me stop you. I don't understand why you haven't pointed out the words led to. I mean, it isn't original information that triggers the investigation. You've got more latitude with led to. And the False Claims Act does not use led, does not use led to. That, to me, indicates, well, it may or may not, but I don't understand why, and I don't think your colleague has either, talked about the use of led to, which makes you think ultimately they're going to investigate this. It doesn't say triggered. If it said triggered, I think you'd have to admit you'd be out of court.
that would be a very different case. I agree, Your Honor. And the led to language does indicate that, and it's information that has to be follow, that has to lead to the investigation, not a submission.
Right.
It's information. And the original information, Congress did not use the term submission. It could have, but it said original information. And that's what must lead to the recovery.
Commission, though.
Well, but it was to the commission. What Congress cared about, both under the False Claims Act and under Dodd-Frank, was not how did this information get into the government's hands. If information leads to a recovery, Congress said we have to reward those people. And the reason it wrote the original source provision is that wasn't happening. The government was taking people's information that they were the original sources of, and they were launching an investigation and cutting out the whistleblower. And this court said, oh, Congress realized they killed the goose that was laying the golden eggs. Whistleblowers, if they think they're not going to get credit for original information, there are these technicalities, they stop coming forward. And so we now have a regime where they've done the exact opposite. They have resurrected that regime. Now the regime is, if we already have your information, you don't recover. In 15 years, nobody has fit into that fact pattern that Judge Pan identified, where the information gets to the commission from a third party, the commission does nothing with it, and then the whistleblower submits a TCR and they magically say, oh, well, let's go investigate, and they recover a bunch of money. Never happened. So the problem is we now have a regime that's the opposite of what the impetus was for the original source rule back in 1986. We now have a regime where pretty much all the time, we know all the time so far to date, when the commission already has your information, you're not going to get a reward.
If they act on it right away.
Well, if they act on it, right. But again, we can't find a single fact scenario, and the commission hasn't cited any where that exception has ever happened. So we now effectively have turned the False Claims Act impetus, the history of this phrase, original information, original source, on its head. Congress put that in the 1986 False Claims Act specifically to stop the practice where the government says, we already have your information. We don't need you because we have your information. If you haven't filed a complaint before we launch, you're out of luck. And they said, that's a bad outcome. We want to change it. And now the idea is Congress then turned around and said, let's use that.
Look back provision, right?
Well, that's a
Just to give you some.
The look back provision, again, we have to look at the statutory text, because their interpretation of the statutory text is what's at issue in our appeal. We say that it's in, so that
I know,
regardless
I'm
of
just
whether.
saying it's not so outrageous for whistleblowers because
Well,
there is this kind of safety valve that you've got 120 days after you give it to.
The look back provision, if you really think about it, how do they have authority to write that look back? Under our interpretation, they can write the look back provision, it's fine. Under their interpretation, the look back provision is violative of the statute
No,
because it's
because there's also a statutory provision that says you have to submit it in the way that the commission.
right in the manner, but
And so they've decided this is the manner.
right. But if they say the phrase provided to the commission means you handed it to the commission and that led to Judge Henderson's
I
term.
know, but in the manner in which they choose, and they say, we treat this as voluntary, we treat this as. They're giving grace to the whistleblower, okay? I don't think that you should be saying they shouldn't be doing that.
well, no, I'm saying under their interpretation, they can't do it because their interpretation is Congress was clear. You must deliver your information personally in the form of a TCR.
Right.
Now,
And you agree that you have to do that under any interpretation.
yeah, exactly. We agree. The other way you provide the information is through a TCR. Now, Judge Childs points out that what happens if that's 5 years later? Well, first of all, what our client did was hand it to another federal agency. That's not going to
Well,
happen.
he handed it to a journalist.
Well, no, but he also handed it. First, his agent went to the Justice Department. He went to the Justice Department.
He handed it to a
Well,
journalist.
actually, I
The
take it.
journalist
You're
gave it to
right.
the
I stand.
Justice Department.
Yes, exactly. But he told him, take this to whatever federal agency it needs to go to.
Right.
And the
And then the
journalist picked the
agency
Justice.
said he should really go to the SEC.
At some point in the process, the agent told, the Justice Department told him that, but it's not in time. I mean, I don't know what happened in that context, but the point is that
Really not know what happened in that context, or can you just not say?
it's just not in the record.
Okay.
I mean, I can say all kinds of things that aren't in the record, but the court wouldn't be happy with me if I
All
did
right.
that. So the thing I want to emphasize here is that the regulation that they pass is inconsistent with their own current interpretation. It was perfectly consistent with the interpretation that they had a year ago. It was perfectly consistent with that interpretation, but their new interpretation depends on the words Congress used, meaning one thing and one thing only. Provided to the commission, voluntarily provided to the commission, means you have to hand it over, and that's what leads to the investigation. And with that 120-day look back, that can't work, because what if you give your information to the Justice Department on day one, and then on day 30, they hand it over to the SEC. The SEC opens an investigation. Okay, your information to the Justice Department in that circumstance, under their interpretation, that was not provided to the commission. And so how can the commission then pass?
You have to provide your TCR within 120 days, and then it'll be considered that you predated the Justice Department.
Yeah, but
you're first in line.
But under their interpretation of Congress's words, that violates the statute. They
I don't
say
think it does, because the Congress's words were you have to submit it in the manner that the agency decides, and this is what they've decided.
right, but they say the
So-
phrase voluntarily provided to the commission means personally handed to the commission and led to the investigation. That's what they say Congress required.
Right, and so in
But-
this look back provision, they're going to say, we're going to consider it as if you came first.
But that's
They're gonna
saying
consider it that way. I don't think that you should be arguing against something that's favorable to whistleblowers. This is favorable to whistleblowers.
Your Honor, it's favorable to whistleblowers under our interpretation as well. What I'm saying is their current interpretation, which they changed it in a way that's
And we
not
agree that they're
consistent with
allowed
the
to change
statute.
it.
They are allowed to change it, but they are not allowed to change it in a way that is inconsistent with the statutory text. And so that is the problem, is that if the phrase voluntarily provided original information to the commission that led to an investigation, in the circumstance we're now describing, that is not satisfied. And you now violated congressional directive as they interpret that directive. And so I don't know how they can I agree it's favorable to whistleblowers, but I don't know how they can enact it under their current interpretation. The original commission.
Under the provision of the statute that says in the manner that the commission decides.
I appreciate that, Your Honor. I accept the
Clean
court.
up your argument. We'll give you a couple minutes and reply.
I told the clerk I wanted 3 minutes for rebuttal, and I forgot to mention that to the court, but I would love some rebuttal time if the court, will.
Mr. Yoder?
May it please the court. Stephen Yoder for the Securities and Exchange Commission. Congress designed the whistleblower statute to motivate individuals to tell the commission about wrongdoing so the commission can bring an appropriate enforcement action. That design is evident in the statutory command that a whistleblower must provide information to the commission in order to lead to the commission's action.
Do you think led to means triggered?
We think that led to means what is set forth in Commission's Rule 21F4C. This court previously we cited in our brief that that rule sets forth the exclusive conditions for satisfying the led to requirement. So we believe that the commission's interpretation of led to in that manner is exclusive, and that's how we interpret it.
Does that regulation amount to trigger?
In some
reading.
in C1, it could be compared to trigger because the question is whether the submission of information caused the staff to open an investigation, reopen investigation, or inquire into new conduct. And so I believe that could be analogized to trigger. C2 speaks to substantially contributing to an investigation or action that's already underway. That's much less analogous to triggering. Is that responsive, Your Honor?
Yep, thank you.
Sure. I would like to respond to my friend's argument about B7 and alleged inconsistency with the commission's current interpretation of the statute. I mean, the commission interpreted its statute and reinterpreted it and clarified its interpretation in 2025 in response to the Supreme Court's decision in Digital Realty, the Second Circuit's decision in Kilgore, and the Third Circuit's decision in Doe, as reflected in our brief. And we believe I would submit this is exactly the sort of thing that the court would want the commission to do, is to stay attuned to developments in the law and actually respond to criticism that it receives from courts in litigation. Now, in terms of B7, that provision is not an issue in this case because, as my friend conceded, he is not challenging the denial of an exemption under that provision. I would point out for the court's benefit that the commission adopted B7 as part of its whistleblower rules in 2011 when Chevron was still the law of the land. And the commission understood it had some degree of flexibility under the statute in order to, as Judge Penn put it, allow some grace for whistleblowers.
And what do you think is the policy behind the whistleblower must be the provider of the information, meaning directly as opposed to indirectly through someone else?
Yes, it's is exactly what Judge Penn said. It's Congress's purpose to incentivize whistleblowers to come tell the commission. I mean, that's reflected in the Digital Realty decision. Above all, Justice Ginsburg's opinion for the court could not be clearer. She said that the definition of whistleblower providing information to the commission is clear and conclusive. She was speaking in the retaliation. Sorry.
Well, I was going to say, so the whistleblower could give information that actually leads to the prosecution, but we seem to be hung up on, but must provide to the commission directly.
Yes, that's correct.
Even if the information did lead to the prosecution of the information.
Yes, that's correct. And I would point out that the statute does not say either directly or indirectly.
Right, but it seems like we're focused on that the whistleblower must provide it, and then is that provision directly?
Exactly. That is the commission's
So
interpretation.
how does that incentivize the whistleblower? Because if you got the information that led to the prosecution and that was
Yes.
successful, then how is the beginning piece about however the information got to the commission, as long as it attaches to that whistleblower, why does that matter?
Understood. It matters because Congress wanted whistleblowers to come to the commission so the commission could take action. And Congress easily could have enacted whistleblower statutes for other federal agencies. And in fact, Dodd-Frank did. Dodd-Frank separately enacted a whistleblower statute for the CFTC, which operates according to its own terms and which my friend has cited in his brief. And so I would point out that Congress did this for two agencies. It did it in very limited, narrow fashion to encourage people to tell those agencies specifically. My understanding is that since then, the Justice Department has started its own whistleblower program. And there's nothing to prevent Congress from doing this for individual agencies across the board, wherever it sees the need to do so. But this particular statute was enacted with the Securities and Exchange Commission in mind, and that's why we believe that our interpretation is the better interpretation that this court should accept. I'd also like to speak to my friend's discussion about the False Claims Act. The False Claims Act, as you know, is about relators bringing private actions on behalf of the government alleging fraud against the government of one sort or another. In that context, there is no question of the provision of information. The relator doesn't have to provide information to herself before bringing an action. Even though Congress borrowed from that statute, it made important changes when it crafted the Commission's whistleblower statute. One of those changes was to insert language about providing information to the Commission that leads to a successful enforcement action. And as the panel already pointed out, the False Claims Act does not contain that similar led to language. That's an important linguistic distinction between the statutes, and as we explain in our brief, it reflects the different operation or function of the statutes, private actions versus commission actions. And the original information exclusion was adopted in the False Claims Act in the 1940s, as I understand it, and it was later amended to include, pardon me, I should say, the original information language does not appear in the False Claims Act per se. The False Claims Act contains a public disclosure bar. It was adopted in the 1940s to preclude relator actions where the relator is simply repackaging information that's already in the public sphere. In 1986, Congress amended that to add an exception for a relator who's the original source of the information in the public sphere. Congress borrowed from that, obviously, and when talking about original information in the Commission's statute. But as we explained, we view that as a separate requirement from leading to, and we believe it would be unnatural to eliminate the causal requirement between the submission of information and the Commission bringing its action. That would result in the submission of information essentially being a ministerial act. And as you suggested earlier, Judge Childs, that would result in whistleblowers potentially coming to the Commission years later after the Commission has brought its enforcement action saying, oh, well, I was behind that information that you used in your information back in the day. I'd like credit. I'd like to get paid. And maybe in a perfect world, they ought to be paid. I'm not going to dispute platonic fairness, but in this particular context, the Congress was acting to create particular incentives for people to come to the Commission. It's not entirely about fairness from the claimant's perspective. So, for example, a claimant like John Doe could put his career, even his life, on the line to come forward and tell the government about wrongdoing. But that claimant is out of luck if somebody came in a week ago with the same information and that information already caused the Commission to open an investigation. That's not fair, but that's the statute Congress wrote. Similarly, if the Commission brings an action that results in less than $1 million in monetary sanctions, then it doesn't count as a qualified covered action as defined by the statute, and the Commission is not authorized to pay awards. So the statute enacts what I would call rough justice in order to incentivize a particular form of behavior on the part of whistleblowers to encourage them to come to the Commission. And I think that purpose is all the more strikingly highlighted on the facts of this case, where John Doe can't even offer an explanation for why he waited over a year after being told about the Commission's program to report directly to the Commission. I'm happy to answer any further questions the court has. If not, I'm happy to rest on my brief. Thank you.
2 minutes.
Thank you, Your Honor. Appreciate that. I'll be brief. I want to address one quick question about what the incentives were there. The Commission has many incentives to not wait the 5 years that they've talked about. After Friday's decision, it's quite clear. If you wait and you get a call from the commission because they started an investigation, you won't be deemed to be voluntary. If you wait, another whistleblower may, as my colleague noted, another whistleblower may come in and file their case. The commission may figure out the fraud through some other way. There are tremendous incentives not to wait. And, I've been doing this for a very long time. That's not what whistleblowers do. They don't say, well, let's just sit back and see what happens. So I think there are plenty of incentives. And if the commission wanted to put in more, there's a rulemaking process they can use. And the second thing I wanted to do was clarify the sequencing under the False Claims Act, because it clearly, the commission says the original source provision itself was modeled on the False Claims Act. And in the False Claims Act, what you have is if the government has someone's original information, not given by them, but they got it from some other source, and the government conducts an investigation, and then the whistleblower only later files their complaint, because that's permissible, the whistleblower recovers. The idea that Congress took that same tool and flipped it on its head and created a regime where if the commission already has the information, there's no way a whistleblower is going to get a reward except for the unicorn. So it flipped the regime that Congress used as its model. Now, I agree, Judge Pan, there's a reason Congress could have decided to do that. But why would they choose the tool that they use to achieve exactly the opposite effect in the False Claims Act? And I would add, the same Congress that wrote Dodd-Frank amended this same original source provision. So they had it right in front of them when they were writing Dodd-Frank. And yet they chose this phrase, original source, to embody what they meant. They didn't even bother to define it because it was so well defined, because it's litigated all the time under the False Claims Act. And there's no dispute here, and this court has noted, that the purpose of that provision was to stop exactly the regime that the commission has now changed as of a year ago into the regime where there's really almost no way. I mean, if you know the law, if you know about the 120-day provision, you're probably just going to go to the commission with your TCR in the very first instance, because why would you wait? And so that there is that safety valve that the commission says they have.
You need to wind it up.
Thank you, Your Honor. That's all I have. Thank you for the court's attention.
Case number 25-5425, Teva Pharmaceuticals USA Incorporated et al. Appellants versus Robert F. Kennedy Jr. in his official capacity as Secretary of Health and Human Services, and Mehmet Oz in his official capacity as Administrator of the Centers for Medicare and Medicaid Services. Mr. Murata for the appellants, Mr. Baldi for the appellees.
Mr. Murata, good morning.
Thank you, Judge Henderson, and may it please the court, Sean Murata on behalf of the appellant at Teva. If I can reserve 3 minutes for rebuttal. The Inflation Reduction Act, like all major pieces of legislation, is a compromise. One goal of the IRA, as the government says, is to lower the price of prescription drugs. But it also had as its purpose to maintain important incentives to both innovate and to bring lower price generics to market, by ensuring that they are not selected for negotiation too soon and that generics can knock drugs out of price controls, therefore allowing the market to do its job. In the time I have, I'd like to focus on the jurisdiction, the qualified single source drug, and bona fide marketing. I'm happy to talk about rightness and due process to the court to the extent the court has questions, of course. With respect to the jurisdictional bar, Teva is not challenging the determination of any single qualifying single source drug. Instead, it is challenging the definition of the standard that CMS uses to decide what constitutes a qualifying single source drug. And we know that for two common sense reasons. First, we brought our lawsuit before Austedo or Austedo XR was even selected for the program. And second, we are challenging the guidance standing alone. As the court is aware, under the IRA, beginning in IPAY 2029, you have regulations that are going to serve the purpose of the guidance. If you can challenge notice and comment regulations, which I think the government would have to concede that we do, we can certainly challenge the guidance that take the place of that. But on the text of the judicial review bar itself, this court is not writing on a blank slate. Congress used the word that you cannot challenge the determination. And in cases like McNary, in Grace, and in Castaneras, the Supreme Court and this court has laid out the line as to what is challengeable and what is not challengeable when the word at issue is determination. You can't challenge particular factual conclusions, but you can challenge the general written policies that govern those conclusions. Here we are challenging the general written policies. The government, and we have the courage of our convictions with respect to that line, because one slam dunk argument that we have is that even under the government's own definition of qualifying single source drug, as inaccurate as we believe as it is, Austedo and Austedo XR are not owned by the same manufacturer because two different entities own the two NDAs. But we're not challenging that in this lawsuit because it's barred by the judicial review bar, because that is part of the determination as to what constitutes a qualifying single source drug. Instead, we have to go a step backwards in the process and say that we are challenging the overarching definition. The government's response rests on Novo Nordisk from the Third Circuit. But as we point out, Novo Nordisk in that case was asking for much different relief. It was asking for the deselection of its particular drug, which is the very thing that the judicial review bar bars. If the court doesn't have questions on its jurisdiction, I'll move over to the qualifying single source drug definition. Here, the IRA lays out a four-step process, and you have to move through all four steps. It's a convoluted statute, as many things are in the Medicare Act, but it's fairly clear what the order of operations. First, you determine the universe of qualifying single source drugs using the definition that Congress laid out. Second, you determine how much you are spending on those drugs, aggregating across forms, dosages, package sizes. Third, you put those spending in a rank order list. And then four, depending on your IPAY year, you cut off the number of drugs, and those are the drugs you are going to select for negotiation. Our case is about step one. What is the universe of qualifying single source drug? The problem is that the statute that the government relies on, the aggregation provision, is looking at stages 2 and 4. It's saying when you aggregate, when you select, look across all of these things. But those statutory definitions have baked into them a presumption that you have already decided what the qualifying single source drug is, because it says you aggregate across the qualifying single source drug.
So you don't look to one application.
You don't look to one application, but you do look to one NDA. And the government says, well, why would you say applications if you didn't mean a single active moiety? And our brief explains that. It's that you can have supplements, you can have amendments to a single new drug application. And so our reading makes sense of all of these provisions. It's a more modest reading than the government has, but it still makes sense of everything that's in the statute. And it's very common to
Does it make sense of the provision that says that CMS must consider data that is aggregated across dosage forms and strengths of the drug, including new formulations of that drug, such as an extended release formulation, and not based on a specific formulation or package size, et cetera? Because in your case, your extended release formulation is under a different NDA. So how would this provision apply to your case?
Well, it applies to our case because they're different NDAs, you don't do the aggregation, but you can have extended release.
But doesn't that suggest that your interpretation is wrong because they intend you to do the extended release formulation?
Oh, not at all, Judge Pan, because you can have extended release under the same NDA. We note in our reply brief Dimetame, for instance, it's an older drug, but you have an extended release that is a supplement to the initial NDA. It's also relatively common to have different forms of a drug to fall under a supplement to the original NDA. So Eliquis, which is a selected drug, has an oral suspension.
Doesn't this all suggest that Congress didn't intend to be limited by NDAs? Because they want extended release formulations to be included in the aggregation.
I think that's
regardless of NDAs.
Oh, I think that's the key point. It didn't say regardless of NDAs.
Well, they don't mention NDAs. They don't want NDAs to limit this. They want extended release formulations to be included. Yeah.
Oh, no, but I think I think what they're saying is sometimes extended release is under the same NDA, sometimes it's not. And when it is under the same NDA, include it. It's not limited to drug product. This is a section
That's
that's.
your interpretation, but it's not supported by the statutory text, which wants it included regardless of the NDA.
I mean, I think you are adding, Judge Pan, regardless of the NDA, because
Because it just says we want it included. Why should NDA stand in the way of this? This is what Congress wants.
oh, but what Congress wants is it wants aggregation across forms and dosage and package size for the same NDA, because that's the key point of the steps I was talking about at the beginning, which is that, you know, the provision that we're
Why do you
talking
think
about.
Congress wants it to be reliant on NDAs? What's your best argument for that Congress intended that?
Sure. So what Congress intended that for this reason. First, they were adopting FDA's process. They were importing the FDA approval process into the IRA. And even the government agrees.
That doesn't mean that it's focused on NDA. It can just be drugs that are approved.
Oh, but I think even the government agrees that if you carefully walk through the set of cross-references that Congress put into the IRA, you end up at Section 21 U.S.C. 355, which is an
That's definitely
NDA.
the backdrop.
It's the backdrop and it's the soil that Congress put it in. But if you want a policy reason for it.
No, I'm trying to understand why you think Congress intended this based on this statutory language.
Sure.
Because it uses the word drug throughout and talks about aggregating all these different things across dosages.
And so when I say it's question begging, Judge Pan, what I'm saying is you have to assume what is the drug, and you find out what the drug is by going to Congress's reticulated definition of qualified single source
Doesn't
drug.
this suggest that the way that they talks about drugs, that they intended the whole thing to be aggregated? So the CMS guidance says it's across dosage forms and strengths. And then we have in a section D1A, you know, the data that is aggregated for expenditures is across dosage forms and strengths of the drug, single drug, including new formulations of the drug, such as extended release formulation, not based on specific formulations or package size. On the drug price, it must consider applications and approvals under 355C for the drug. I mean, this doesn't suggest that we're limiting based on NDAs. And also CMS must compute and apply the maximum fair price across different strengths and dosage forms of a selected drug and not based on specific formulation or package size or tag. I mean, it just, the whole statutory scheme suggests it wants to aggregate different forms of the drug. There's no suggestion that it should be limited by NDA based on what they're trying to do here.
Well, because what NDA is, it tells you what the drug is. I mean, I think in the FDA world, you do a lot of acronyms, so it sort of hides what the concept is. NDA is new drug application. So an NDA is so if something is a separate NDA, and as we point out, FDA does police the line between supplements and new drug applications. It is reasonable for Congress to say that when FDA has determined that something should be a new drug application, that is a new drug and is therefore a
So an
different
extended
drug.
release formulation of the exact same drug could be under a new NDA.
Well, it's not the same drug. I think that's the point.
Okay, of the same active moiety.
Well, and I think that's the key point, which is Congress never used the word active moiety. Congress is aware of the
You also
concept of
never use
active.
the word NDA.
It does through its series of cross-references. By getting you to 355, it gives you a NDA
I
specific.
could argue that they meant active moiety then.
I do not.
If you look at the entire intent of this, what they're trying to do is figure out what are the most expensive drugs. So those are the ones that we'll negotiate. And they want to go across different dosages and formulations, et cetera. And those are the ones we're going to negotiate. They don't want to carve out what you're saying based on NDAs and have an inaccurate picture of what people are spending all their money on drugs.
But I think, again, it is assuming the conclusion of what the drug is. And the point is that we find out what the drug is through the definition of QSST.
I know that that's your theory, but it doesn't seem to be consistent with congressional intent and what they're trying to do with this whole program.
I mean, I think we did, because the IRA is a set of compromises, we figure out how those compromises come out in the wash by looking at the language they're using. And this is a section that's entitled Clarifications and Determinations. And what the government is suggesting is that clarification is a very big tail that is wagging the reticulated definition of qualified single source drug that appears separately in the statute. When Congress says this is what qualified single source drug means, it excludes all the other definitions that aren't included. And I think that's the key point. And you can still have aggregation under our view, including
But I just don't think
aggregation
the
of XR.
definition of qualifying single source drug necessarily has to be by NDA. They could just mean as covered by Part D of the statute, and is approved under Section 355C. It could just be as the government posits, just things that are approved by the FDA.
But the FDA only approves by NDA. I mean, the whole world of FDA approvals is the FDA does not approve
But
active moieties.
it approves by NDA, but all of the different drugs under different NDAs are all approved under 355C. So there are other ways of interpreting this without limiting everything to NDAs.
I think it's just not the way
Because the language just
FDA.
says under Section 355C. That doesn't mean under each specific NDA under 355C. Could just be everything that's been approved.
But FDA approves applications for new drugs, and that is an NDA. And I
But it
don't
also
even take.
approves supplements, et cetera, right?
Right, and they do so under the initial NDA. And I don't even to understand my friend from the government to say that I'm inaccurately describing FDA's system. They are just suggesting that, well, the IRA means it somehow differently. It's a
Just
different.
means generally approved by the FDA without getting into the weeds of by NDA. Why can't that be an appropriate reading of this?
I think it's not the better reading. I think it's because Congress borrowed the FDA system as they found it rather than trying to modify
Why isn't
it.
it the better reading? Because it's consistent with all the other provisions which seem to suggest that Congress wanted to aggregate across all different formulations, dosages, et cetera.
Because it leads to all sorts of surplusage. Because remember, the statutes we're talking about say you aggregate across the qualifying single source drug. If Congress meant all of that to be baked into the definition of qualifying single source drug, then why do they have all these additional sections that the government is relying on? In the government's view, qualifying single source drug by itself has already gotten you to active moiety. And that tends to be the problem. I think they were also doing other violence to the statute, which they then have to patch over. So for instance, they have the problem where are we getting this notion of the same manufacturer from? That's not in the statute. Well, they say, well, because it's active moiety, but because it's the manufacturer, we have to look at whether it's the same manufacturer or not.
Because you have to negotiate with each manufacturer.
But I think it's much easier under our reading to say that, well, the manufacturer is the NDA holder. Now, whereas under the government's view, you have, and then they say we're doing all of this to prevent, product hopping, or we're doing this to prevent gamesmanship. But the gamesmanship that the government does not protect against is you just give the NDA to a different subsidiary and then they are different manufacturers. And FDA doesn't police that or control that. I think that's a problem. You also have the problem under the government.
Reading, I'm just thinking this through as I sit here. If two different manufacturers have drugs that use the same moiety and do the same thing, and together they account for, maybe they're the most expensive drug in America. Then everybody's using this moiety from these two different manufacturers. I guess they're different manufacturers.
Yeah, so even under the government's view, they don't get aggregated.
I'm just trying to think, like, the purpose is to figure out what is the most expensive drug, and that's the one that we're going to negotiate. And I just feel like your interpretation seems to undermine that.
But I think the government's does too, because as you, I think, sort of reasoned out in real time, if they're different manufacturers, they don't get aggregated, so they don't get negotiated. And that's the problem. So they also have the problem that when it comes to knocking out things from price controls, you can have drug products that do not have generic competition. So for instance, if there's a generic capsule that knocks out the tablet, even though the people who rely on tablets are not going to have a cheaper generic, which is Congress's entire goal, which was to say that we have generics knock out when there is effective competition. And here there wouldn't be, but under the government's view, they accept that that would lead to knocking it out because of their reading of aggregation, which again seems contrary to how Congress wanted to interpret the statute, or how Congress wanted this to work out. Because for people who take tablets, maybe because they need to split it in half to receive a different dose or something like that, or because they need to crush it up or something else, the capsule is not a replacement. And so they're going to be subject to a more expensive brand name drug because of how the government is aggregating across NDAs.
Can we go on to your marketing argument?
Sure.
Okay.
So with respect to bona fide marketing, the government seems to essentially throw all in on the notion of they need to prevent bad faith marketing. But the reality is when it comes to inflation and rebates, when it comes to the Medicaid drug rebate program, when it comes to Hatch-Waxman, 3 programs that all use the same word, marketed, there was no similar concern about bad faith marketing. And there's a reason for that, because the Office of Patrolling Bad Faith Marketing is the antitrust laws, it's the state attorney generals, it's the antitrust division.
Isn't the term "is marketed" governing this provision?
Sure. So it is approved and is marketed pursuant to such approval, which if you distribute the is, it is marketed. But even if you think that that creates
Which means that one generic drug being pushed into the marketplace is marketed.
So I think there is a couple things, Judge Childs. Even if you take the is marketed tense to require an ongoing marketing, there is no de minimis exception to it, which is what we really take issue to. And I think some of the government's arguments go to the question of whether there is marketing at all. But there is nothing that we're in the statute that says bona fide marketing, which is something above and beyond marketing, clearly, because it's a different set of words. And of course, Congress uses the words bona fide throughout the U.S. Code. They use it in the Inflation Reduction Act. Congress knows how to say bona fide when they want. And the real problem that you have with the government's interpretation is that for the drugs, like some of Teva's generics, that are going to be marketed very close to that March 31st cutoff, the forms of data they are going to be relying on are inherently time lagged. And so what the government gets is an extra year of price controls because they won't deem it bona fide marketed. Whereas if they simply ask, is it marketed? We will certainly show that that product is on the market, even if it is not in exactly the way or in according to the inchoate bona fideness that CMS has decided to place upon it. So
Yeah,
that
but then what context would you say that CMS couldn't try to detect any sham or any fraud with respect to marketing, even if you don't use the term bona fide marketing?
I think you could say that, like, if it's the sham one pill, maybe that just isn't marketing under the dictionary definition, but there's no like de minimis requirement or like a quantity that must be on the market at any given time or be reflected in certain sets of data, or something that is beyond simply showing that the drug has been exposed to the market and is available for purchase, which again is the same thing that CMS does in all of these other contexts when they have asked, is a drug being marketed?
So doesn't your argument have to boil down to the definition the agency has adopted conflicts with the statute?
It does.
Like the statute cannot allow them to interpret marketing in this way?
That's
Because
right.
even though I think you have an argument, I don't see that their definition of marketing is precluded by the statute.
Oh, well, the question isn't whether it's precluded. I think it's whose is best under the statute, because we're not under Chevron anymore.
Right.
But I think it's also that
But why is there's not best? Because it should be a genuine marketing, because that's the whole purpose of this, to see whether or not there really is competition from a generic drug.
because Congress didn't say bona fide. I mean, they have to acknowledge they are
Maybe they
adding
meant
words.
bona fide, though, because why would they want it to be a sham generic that like one has been sold and it was with an agreement between the drug company
Sure.
and the generic?
So I think there's a couple different things, Judge Pan. The government tries to back me into this corner where they say, well, what you're defending is fraud. And I'm not. All I'm saying is that,
You're saying fraud would be allowed.
I'm not saying fraud would be allowed. I'm saying that fraud is being policed not by the Inflation Reduction Act, but by the Antitrust Division and all the state's attorney generals and the private plaintiff bar, that if we collusively agreed with someone else to only sell one pill to knock their innovator out of price control, I would not want to be their class action counsel is all I can say. And so I don't think it's unusual for
That's not
Congress.
consistent with Congress also not wanting there to be fraud within this provision.
I don't think
Even
it's
allowing for fraud.
If that's what Congress sort of had in its mind, you think it would be expressed in the text and it's not.
Well, maybe it shouldn't need to be because of the whole purpose of this, it seems that the intent is to actually talk about real generic drugs that are available and therefore affecting prices.
But again, throughout the Medicare Act and through other healthcare statutes, we have had the same on-off definition of marketed without any of the same concerns about fraud or, CMS saying, well, but how are we going to solve the problem of only one pill? So to say that when Congress took a term that it has been used in this field for a very long time, the word marketed, why have it mean something different here than it does in all those other programs? And that, I think, is the thing that the government struggles to explain. Unless the court has further
We'll give you
questions.
some time in reply.
Thank you.
Mr. Baldy?
Yeah.
Good morning. May it please the court, Max Baldi for the government. I'd like to circle back to the judicial review bar and talk about what these determinations are that CMS is required to make under the statute and why I think they fall squarely within the judicial review bar. And so to do that, I want to just take a second to discuss how drugs are selected for negotiation. This is all in 1320 F-1 and in 3 subsections. In subsection E, CMS has to determine what qualifying single source drugs are. So it identifies all FDA-approved prescription drugs covered by Medicare that are at least 7 years old and for which there are no generic competitors. And then it excludes some things from that definition, generic drugs, plasma-derived products, orphan drugs, things like that. That's the step, subsection E. Subsection D, it has to determine the negotiation eligible drugs. So again, it's expressly instructed to use data aggregated across forms and strengths, including new formulations. It takes a list of qualifying drugs. It removes small biotech drugs and drugs that have already been selected. It aggregates the spending direct data, and it ranks them by Part B and Part D spending. And the top 50 Part B drugs and top 50 Part D drugs are negotiation eligible. Third step, selection. This is subsection B. CMS takes the negotiation eligible drugs, combines B and D spending for each drug, ranks them by total spending. And then depending on the year, it'll take the top 10 or 15 or 20. That's it. It is a completely non-discretionary process in which the inputs inexorably lead to the outputs. So when Congress says in 1320 F7, there shall be no administrative or judicial review of the selection of drugs under 1320 F1B, the determination of negotiation eligible drugs under F1D, and the determination of qualifying single source drugs under F1E, it is referring to that process that is where there is no way to distinguish the definition and how that definition is applied from what comes out of it. And I think when you look at it in this context, this statute intends to preclude review of the kind of challenge that Teva has brought here.
What is your best case on that? Because this circuit has gone both ways as far as the justiciability of statutes as complicated as these.
Yes, Your Honor. I think DCH Regional Medical Center is our best case. So this is a statute that provided additional payments to certain hospitals that was equal to, you have to multiply 3 factors estimated by HHS. And Congress said there should be no administrative review of any estimate of HHS for the purposes of determining those factors. And this court held that the provision barred a challenge to the data sources and methodologies used to compute the factors. And it said the reason that the judicial review bar covered those provisions was that the two were inextricably intertwined. And so the review bar precludes review of both. I think that is our best case. It's not our only one. I think, the structure of this statute, making specific reference to the determination under this section is very similar to this court's opinion, your opinion in Knapp, where Congress said that there was a prohibition on reviewing a process under a certain paragraph. And this court said that was best read to refer to the entire process, and the statutory cross-reference confirmed that.
And how do you distinguish this from McNary?
So McNary is about procedural opportunities, not substantive relief. McNary was a circumstance where you had an agency making determinations based on a hearing process about whether people could be granted a certain immigration status. And the plaintiffs there sued and said, we're not challenging the determination that we're not eligible. We're saying that the process that you've set up for this hearing is fundamentally unfair. We want a due process holding that the process that we need a different process, and then we'll go run this whole procedure again, and maybe we'll win or maybe we'll lose, but it'll be, it's a collateral attack on the process. Whereas here, the inputs and the outputs are the same. And when those two things can't be distinguished, then the review bar has to cover everything. And I think the way you know that.
Never didn't limit itself to procedures, did it? Even though it concerned procedures, the language in it is broader than that.
McNary's a
It
case.
doesn't preclude review of general collateral challenges to practices and policies by the agency.
That is, McNary was a case about procedures and there was some broader language in it. In this case, in this court, in many cases has sort of had to put meat on those bones because this court gets more of these preclusion cases than any other court. So I would point to, for example, to the description of McNary's holding in Federal Law Enforcement Officers Association. And that's a slightly different case because it's about channeling rather than strict preclusion, but it's an explanation of McNary and how it was, this court has interpreted that language more narrowly.
But if courts can't review CMS's statutory interpretation and CMS essentially tries to interpret in a way that would rewrite a statute, you're trying to say that we don't have an opportunity to look at that?
I think that's what preclusion of judicial review means. That's what it always means. And if CMS were to go off the rails, the remedy there would not be judicial. It would be political. It would be up to Congress to rein in the agency. But I think the way you know that this statute means to preclude, the determination, for example, of what the definition of a qualifying single source drug is, and that sort of determination, is that if that judicial review provision, which specifically calls out all these things, didn't preclude this kind of challenge, it's really unclear what it would preclude. I think the only thing that
It precludes the selection of the drugs and the determination of which drugs and which prices.
Right,
It doesn't preclude the procedures and the policies. There's a presumption that we can review things like that.
So, Your Honor, there is no discretion in CMS's part to select a drug, right? It's not like they get a list of the top 50 and then they pick the 10 that would be most effective. They make a list, they rank the list, they select the top number of drugs on the list. There's no discretion in that process. I think the only thing that this review bar would cover would be an Excel error that they've added the numbers together incorrectly. And that just does not seem to me to be where Congress said in F7, it took all of these specific determinations and said, this is precluded, this is precluded, this is precluded. To think that what Congress meant was there is preclusion if the agency did the math wrong, but not preclusion of the actual decisions that are leading to the determination of what a qualifying single source drug is. That just doesn't strike me as a plausible interpretation of what Congress did with this judicial review provision. I think what Congress wanted to do here was to say, look, this is a high stakes program. There is a lot of money involved. Every manufacturer involved in this is going to sue, and that is what has happened. We want to preclude judicial review of some set of these decisions so that we can, the agency can launch this program and get going, and we can start, experiencing the benefits to both Medicare beneficiaries and the FISC without tying it up in litigation for years. So I can move on to the merits, but I don't want to leave this topic too quickly. So on the merits, I think, look, the statute says across the board, aggregate, aggregate, aggregate. That is the direction of the statute. But I think I want to start by pointing to something my friend said, which is to say that he wants you to look to a highly reticulated definition of qualifying single source drug. But there's a circularity problem to his definition too. 1320 F1E1 says that a qualifying single source drug means a covered Part D drug or a Part B drug that is described in any of the following. There's two subparts. A is drug products, B is biological. A, drug products, a drug M dash, and then 3 restrictive characteristics that is approved under, by the FDA within 7 years, and there's no generic. But we have to start with what is a drug? That is not defined here. We give drug its ordinary meaning. A drug is a substance used in the diagnosis, treatment, or prevention of a disease, or as a component of medication. The ordinary understanding of drug is not what was the administrative process used to approve prove it. The ordinary meaning of drug is, what is this thing that you put in your body to treat a disease? If you were to take 3 kids to a pediatrician, they all had strep, and they get the same antibiotic to treat strep. The youngest gets like a liquid suspension, the middle kid gets a chewable tablet, and the oldest one can swallow pills and gets pills. And you were to say, are all 3 kids taking the same drug? Everyone would say yes. No one would say, well, I don't know, were they approved in separate NDAs or not? I don't think Congress brings into this process the idea of an NDA. I think what Congress says when it's coming up with this list is, yes, it has to be approved under 355 by the FDA. We are not covering experimental drugs. We're not covering drugs that are only available in Europe and not yet approved here. Like, that is the universe of things. It's a broad universe. It is everything that is approved that Medicare and Medicaid are paying for that meet these criteria. But I don't think that means, this sort of statute, if Congress had said, we want this NDA specific version, if we wanted to bring this concept in, this is about the most obscure way you could write the statute. You have the ordinary meaning of a drug, or you could say, well, Congress didn't say a drug means any drug product approved under a single NDA or supplement thereto. If that was what Congress said, Teva's reading is best. It didn't say that. It didn't say anything like that. It said, we're operating in the realm of FDA approved drugs.
And would that include the generics then?
Well, it would not include the generics because when a generic is approved, then it comes out of the definition. And we're talking here because of the structural scheme, the structure of the scheme. We're talking about negotiating with a manufacturer, not some sort of like sectoral bargaining with anyone who has an interest in this single active ingredient. So we have to make sense of this scheme together. But it skips a step to say, well, a qualifying single source drug is a drug that meets these criteria. You still have to figure out what a drug is, and a drug has an ordinary meaning. My friend referred to subsection D3, the aggregation provision is, I think, both the tail that wags the dog and potentially a surplusage. I don't think either of those things are true. In each of these steps, Congress has told the agency how this aggregation should happen. So at D3, it says, you're looking at data. What data are you looking at? How are you considering it? Consider all of this data together. At F3 E1D, it talks about what the agency is looking at when it makes an offer of price. And it says, look to applications and approvals. And I agree that includes supplements to a new drug application. But there's nothing in that text that excludes multiple new drug applications. It refers to applications. In F5A2, we're talking about computing and applying the price across different strengths and dosage forms in the same way. That again is the sort of determination that at that stage, this is how you apply it. And that isn't necessarily obvious that you would say every formulation has the same price. That might be the way you would proceed. It might not. The manufacturing cost might be different. Congress made a decision there. But the entire structure of this scheme, everything pulled together, the words, the purpose, the structure, all tells you that CMS's interpretation is the best.
All right.
And then,
Thank you.
Do you want me to address generic competition or no?
I don't think, do you have any questions on that? I don't
Okay.
think so.
Thank you, Your Honor. The judgment should be affirmed.
All right. How about 2 minutes for Mr. Murata?
Thank you, Your Honor. Let me address the notion that Congress is using a common sense definition of drug in the statute. The Medicare Act does a lot of things through obscure ways, but it's not using common sense definitions of drug. Because if you were to take 3 kids to the pediatrician and say one gets an oral suspension, one gets a tablet, one gets a capsule, are they all taking the same drug? Parents might say that, but doctors might say, well, actually, I need the oral suspension to work exactly the same way. And the way I know that is because FDA has done the work and the manufacturer has done the work to ensure it. Or I need a tablet because I actually need for my pediatric patient to cut that tablet tablet in half. And the way I know that's going to work exactly as well as the capsule did is because the manufacturer did the innovation necessary to make that happen and did it by making it a new drug and a new drug application. And the reason, for instance, the generic is not included, even though amoxicillin is going to have the exact same therapeutic effect as the brand name, is because Congress had to use the technical meanings of these terms to carve it out of the statute. Before I sit down, I just want to say one practical thing about timing, which is that it is essential for Teva that we get a decision before the end of the year, because under Part D, as been mentioned in the brief, the government is not directly paying for these medications. It's third-party plan sponsors that do so. If we were to prevail after January 1st, there would be a lot of questions about how that money comes back. And so we would ask that when the court is taking into account how to order its docket, that they keep that in mind, unless the court has questions.
All right, thank you.
Thank you.
This honorable court now stands adjourned until Thursday, May 7th at 9:30 a.m.
Right? Exactly. Team is looking business. What's that? If I win on jurisdiction, nothing else, I've got great service, but I know where to.